Good afternoon, and thank you for joining us today at the firm's signature CLE webinar series for in-house counsel. My name is Sam Olens. I'm a partner in the Atlanta office and the former Attorney General for Georgia. As many of you know, Dentons is delighted to host a series of CLE webinars at lunchtime over the next few weeks. Today is the first session of the series we have planned for you. We are so appreciative of those who have joined us in the past. Thank you for your continued support. Before we get started today, I have a few housekeeping notes. Presentation materials can be found in the materials box in the upper right of your screen. You may download them at any point during the session. Due to the high volume of attendees, all lines are muted. Our speakers will be monitoring the Q&A box, so please be sure to submit any questions there. The following are a few important items regarding CLE credit. Please keep the webinar window open and at the front of your screen. This is especially important for those seeking Kansas, New Jersey, New York, and/or Pennsylvania credit, as you will need to enter a code word at some point during the presentation. During each presentation, a pop-up box will appear. At that time, our presenters will state the code word and a slide will project the code word on screen. If you're seeking credit, once again, in Kansas, New Jersey, New York, and/or Pennsylvania, please enter the word in the pop-up box at that time. Again, this is only required for those seeking credit in Kansas, New Jersey, New York, and Pennsylvania. If you do not require credit in any of those states, the code word is not required and you may close the box. The September 14th webinar has been approved for 2 general CLE hours in Arizona, California, Iowa, Illinois, Georgia, Indiana, Kansas, Missouri, New Jersey, New York, Texas, and Utah. The webinar is pending approval in Virginia and Pennsylvania. Now on to today's session. This afternoon, we have 2 hours of valuable information for in-house counsel. During the first presentation, myself and Senior Managing Associate Angelina M. Whitfield will share updates with regard to working with state attorneys general, preparing for state AG investigations, and defending against AG investigations and litigation. Following, partner and global chair of intellectual property and technology, Song K. Jung, partner Dr. Stefan Dittmer, and our featured guest speaker, James Pooley, international trade secret expert of James Pooley PLC, will provide the latest updates on global trade secrets. We're excited for our presentations today, and at this time I will start the Attorney General program. So historically, if you look at state attorneys general, their role was very unique among state elected officials in the United States. They were both the individual state's chief legal officer, the investigative powerhouse, a consumer protection arbiter and enforcer, a prosecutor, with those talents changing by state to state, multi-jurisdictional litigation, and a policy advocate. So it was very much a full-time position that kept everyone busy. Traditionally, thanks to the federal theory of parens patriae, they also had the ability to monitor and enforce numerous federal statutes. So in addition to being the day-to-day counsel for the state and executive branch of government, they also were very involved in numerous federalism and preemption concerns. Often that created a friction between the state and federal government, but most of the time, the state attorneys general, DOJ, FTC, etc., worked hand in hand cooperatively. The state AG authority included issuing legal opinions. That's not the same as an opinion from a court, but certainly had much value. Enforcing the state sunshine laws, open records, and open meetings. Defending or challenging state and federal law and administrative actions, sometimes in other states, as well as with the federal government. Often handling criminal capital appeals and actions before the U.S. Supreme Court. In fact, often in most states, the attorneys general were the only ones that were allowed to argue in front of the United States Supreme Court. Also enforcing Medicaid fraud, cybersecurity, environmental, antitrust, and consumer protection laws. Lastly, in some states, the attorneys general had the ability to revoke corporate charters. Traditionally, this role was viewed as nonpartisan, simply being the lawyer. But one of the many things about an attorney general's office that is different than many others is something called a CID that Angelina will talk a lot more about after me. Those are civil investigative demands. CIDs are much broader than a subpoena, much broader than a warrant, and it frankly provides the state attorney general office to request many documents at the beginning of an investigation, and seldom is a court going to limit the scope of that CID. So often what happens is someone such as me or Angelina will work with that state AG's office to seek to narrow or pare down the request to make it much more doable for the corporate client. Additionally, the attorneys generals were involved in multi-state litigation. As you can imagine, none of them have excess employees, excess lawyers, few paralegals. So as a result, the states often work together. One state would take on one part of a brief, another state would take on another part of the brief, and they'd work together. Similarly, states and federal agencies would work together, specifically DOJ, FTC, CFPB. And where that generally evolved is that those attorneys general that sided with the current administration would write amici in other matters to support the administration. Those attorneys general that opposed the current administration would naturally be bringing a lot of the lawsuits, questioning under the Administrative Procedures Act, and frankly trying to slow down the process as much as possible pending the next presidential election. One thing we saw in the last administration was the creation of national injunction requests. Previously, you would seek to get injunctions in your circuit court. But we started seeing under President Trump, district court judges disagreeing with the Trump administration policies, and a district court judge extending a national injunction. That was very new, very powerful, and something that I'm sure will be litigated for years to come. Additionally, you had the appropriate and normal consumer protection investigation, unfair and deceptive trade practices, or called UDAP. As mentioned earlier, the Medicaid fraud investigation, civil and criminal, environmental protection, antitrust, and more of late, the data privacy and data breach investigations. All this changed once the attorneys general worked on a tobacco settlement. That was the first time that you started seeing many attorneys general getting much more in the political rather than the legal vein. And frankly, the dollars in that tobacco litigation were astounding, not compared to the recent opioid litigation, but anything before it. So starting, for instance, with the Obama administration, you saw the Republican AGs acting in a much more partisan manner, attacking the EPA, the brand new CFPB, and the Affordable Care Act. Under President Trump, you started seeing, once again, many actions in those areas, but also marijuana, DACA/immigration. You also, as the Attorney General position became more partisan, saw litigation over the Emoluments Clause, the border wall emergency declarations, and as referenced earlier, the nationwide district court injunctions. Under President Biden, this has simply gotten greater to now include DOE, to include Section 230 of the CDA, litigation involving election integrity, religious liberty, and in fact, just this past week, 21 state attorneys general filed suit, joined action with Planned Parenthood in South Carolina to oppose some changes in that state. Now, when I was Attorney General, it was very unusual to be involved in another state's legal affairs. It was felt to be in bad taste. Yes, you would litigate against the federal government. Yes, you would litigate against the state if that state took action that specifically related to your state's laws, but you would not file amici against a state for political grounds. Nowadays, everything is possible and everything is frankly occurring. And I'm not frankly sure how some of these attorneys general have time to do the job they were elected to do, along with all those other partisan jobs. And let's keep in mind that, one of the funny things people used to say about AG's attorneys general was that they were aspiring governors. And as you look, our current vice president, in fact, was a former attorney general. So more and more they're seeking those higher federal offices. Under President Biden, he created a DOJ task force to literally assist with competition issues. And interestingly, in that task force, he specifically reached out to attorneys general and asked them to be partners with the federal government. So the FTC and the Department of Justice in particular have reached out to state attorneys general. Section 230, one thinks of the litigation with Facebook and Google, antitrust and mergers, UDAP. But what's important here is while much of what attorneys general are now doing is partisan, there are many Republican attorneys general partnering with the FTC and the Department of Justice in areas to include specifically Section 230, where clearly that litigation involving Facebook and Google is not Republican or Democrat. It has become a nonpartisan litigation. Similarly, there have been some recent decisions where the Supreme Court ruled that the FTC did not have the authority it felt it had, specifically with regard to restitution and disgorgement. And in those areas, you could expect more of a partnership between, for instance, the FTC and state AGs, because many of those state AGs have broader jurisdiction that can seek restitution and disgorgement, even when the FTC cannot. Additionally, the FTC just recently rescinded the Consumer Welfare Antitrust Enforcement Standard, which once again is important because it provides the FTC to potentially assume greater authority than they have just historically taken. With regard to the political landscape, there's really only one election this year in our country involving an attorney general, and that is the re-election of Mark Herring, Virginia's attorney general. Those races in Virginia are considered to be close at this time. We also have a brand new attorney general, that being from Oklahoma, Republican before, Republican now. But what's very important is next year. Next year, there will be 30 state attorney general races. For some reason, next year is the vast majority of those races. So as you look at the map, there are many, many states that are going to be having these elections, and noting how active and aggressive many attorneys general have become, they actually make a difference. They make a difference in particular when Congress is slow to act or unable to act. So often as Congress is unable to take action, state attorneys general are taking action. At this point, I'm going to give you to Angelina Whitfield, who will talk about those vital attorney general investigations. Angelina?
Thank you, Sam. So let me make sure everyone can see me. So let's start out with what provokes a state AG investigation. There are a number of different ones that really do come into play. You may have media coverage. There's consumer complaints, which are often taken very seriously by the state AG's office. There are whistleblowers as well who are taken seriously, plaintiff suits and follow-on suits, competitor or vendor complaints, which are often made directly to the office, and other regulators, including other state AGs and multi-state task forces, or in federal investigations. So there's a lot of coordination that may take place as well. And state AGs are often very focused on issues that have local or state impact. And so it's something to be mindful of depending on the industry in which you're active. So what's the big deal with it receiving a CID? CIDs are often very broad. The state AGs have very broad discretion to investigate based on their state statutes. And so CIDs are much broader than your normal litigation or discovery request, your subpoenas, or a warrant. And state statutes provide for a variety of remedies and relief that the state AG can obtain. One is injunctions. That often includes the power to shutter business operations, either permanently or in some extreme circumstances temporarily. Every state does have different penalties, and those can range from compensatory to punitive or just certain other civil penalties. Those are often capped, but they may be per violation as well. And one thing to keep in mind is that while state AG offices are leanly staffed, the state's ability to share information or to coordinate with other regulators helps to boost their resources and share those. So what do you do when your investigation has been initiated? Well, the state AG has those different vehicles that it can use to obtain information: CID, civil subpoena, inquiry letter, or in some cases, a request for an informal or a formal interview. Typically, though, you're going to be receiving a CID, and the first step is really to assess the scope. As I mentioned, tends to be broad. So assessing how broad it is helpful both for your purposes of engagement with the AG and also to determine whether or not a challenge might be warranted in part or in whole. Given the state AG's broad investigatory powers, challenges to a CID are difficult to prevail upon, as Sam noted. A more recent case is Texas's probe of Twitter, in which Twitter sued to enjoin the CID, objecting to the broadness. And the court granted Texas's motion to dismiss, finding that the CID was enforceable because of the state investigatory powers that were granted under the statute. So it's really best to engage with the AG before you bring a challenge in order to understand the nature of the investigation and to try and narrow the scope. A challenge also may impact your rapport with the staff. At the state level, a good relationship and a working knowledge of the office is particularly important. You're often dealing with the same people over the course of the investigation, which can range over years. And so you want to have a good working relationship in that regard. Another aspect is to assess the due date. The statute often limits the time to challenge a CID. So we have a complete process that demands high ethical standards. One thing to consider is issuing your litigation hold, which we'll talk about in just a minute, and building your narrative based on the facts that you gather. You'll also want to, generally investigations are confidential, but addressing the state open record laws and the equivalence of FOIA, as well as the statute's provisions for confidentiality of the statute of the investigation that's issued, that's been conducted under the statute, will help you negotiate a confidentiality agreement. Conducting an exposure analysis, coordinating with outside and internal folks, and initiating your high-level AG office contacts are all proactive steps that can be taken. One consideration is not to assume that the AG knows a lot about the industry or how your business works. This is really an opportunity throughout to educate, advocate, and to try to limit the investigation to make it easier to narrow the scope of the CID. A key high-level AG contact is also going to be familiar with the various AG organizations and may have contacts within those. So I think we'll cover that towards the end. But the last part is, to the extent that there are multiple state inquiries or a formal multi-state or a federal and state joint investigation, you'll want to sync those inquiries for efficiency and beneficial negotiations. So in terms of developing a plan when you're under investigation, there are a variety of steps that range from document collection and review to witness interviews. You'll want to analyze the evidence that's gathered. And then there's internal reporting, remediation measures that may need to be taken, and where appropriate, external reporting. So we'll start with the document preservation and collection. The first step is to issue a lit CID, a lit hold CID, a lit hold. It's important to check that you have proper preservation methods and settings, make sure that all the relevant documents are preserved. Hiring outside tech consultants or companies to help with that preservation effort can be very helpful. And then instructing your employees not to delete or destroy the evidence where you have employees that are conducting work through their personal devices that may also be subject to the CID. And so make sure that that evidence is preserved as well. The failure to do so can lead to obstruction of justice charges. So it's important to communicate with your employees about what the steps they need to take are, and to also remind them. So best practices include signing a disclosure form to ensure that the employee understands and the need to cooperate during an investigation when their documents are implicated. Having a computer message remind them that the documents and communications are the possession of the company is also helpful. And then working with your outside counsel, as previously mentioned, can be helpful. Because of the broadness of these CIDs, volume can be an issue. So when you're dealing with the state AG, take stock of what you have, isolate what the necessary materials you think are, and then communicate with the AG about the burdensome volumes. Sometimes narrowing the scope may involve negotiating the locations of information, custodians, or search terms. Consulting experts can also be very helpful early in the investigation. They're particularly useful whenever you have complicated reviews such as financials, accounting records, or computer forensics. There are certain best practices, such as having an expert review companies' accounting and banking records 1 to 2 times annually to ensure compliance, and using them to create internal records, record processes and controls to prevent improper payments or expenses from slipping through the accounting system. All of that will be helpful as you're going through and looking at what the company has and the information that it contains. If you're working with outside counsel, make sure that the outside counsel are the ones who retain the expert so that they can invoke attorney-client privilege or work product protections where appropriate. The identity or existence of a consultant expert is not usually disclosed during the investigation, and so there's some safety there as well. So turning now to gathering the information from witnesses. The documents that you gather from the different resources and locations that you have in your company are going to lead to the individuals that are going to be pertinent for interviews. So when you're hiring company employees, conditioning their employment on cooperation is important, including the interviews. When you are interviewing a company employee, you must administer an upjohn warning. That is the corporate equivalent of a Miranda warning. Those warnings remind the employees that you and or the outside counsel represent the company, not the individual employee, that the interview is covered by attorney-client privilege, but the privilege belongs to the company, not to the employee. That allows the company to unilaterally waive that privilege at any time and to disclose it to anyone, including government authorities. And the reason that matters is because companies may waive privilege in the hopes of getting cooperation agreements. So failure to administer the warning can damage the quality of the evidence you receive, impair prosecution down the road, and compromise the company's ability to receive cooperation credit throughout the investigation. Generally, you want to interview in ascending order of importance from least important and culpable to most important and culpable. That allows you to gather a much larger information set before you conduct the more critical interviews. An interview should be attended by a principal questioner and a note taker. The notes should only be a summary. They should not have off-the-record comments or other non-factual information. If you as in-house counsel are not serving as the principal questioner, it's best if you don't attend the interview so that you don't become a witness. The exception there, of course, is going to be if your presence is going to facilitate the flow of information and comfort the witness. One other consideration is that you'll want to ask the witness to keep that interview confidential. In the event of a deposition or other interactions with the AG, it's important for the witness's information to have been cabined and not be disclosed to other employees. So when you're putting together the witness interview report, it's best to promptly and contemporaneously write a summary report of the interview. It's very careful. You want to very carefully consider what to say. So you summarize the factual information that the witness has provided. Really want to stick to the facts and only the facts, because the possibility exists that someday that interview report may be turned over to the government investigators, either if the witness becomes available or, as I mentioned, for cooperation reasons. So it is important to exclude attorney impressions and strategic considerations accordingly. So those should be documented elsewhere. So we'll pause now for the CLE code word, which is Emory. So if you're licensed in Kansas, New Jersey, New York, Pennsylvania, please write that code word in the CLE word box. Pause for a moment. Okay. So moving on to conflicts. As mentioned, your in-house corporate counsel represents the company, not the individual employee. However, there are conflict issues that sometimes arise whenever you are conducting interviews or otherwise carrying out tasks in the course of your representation. Individual employees who have criminal exposure may require separate counsel. So where outside counsel, as well as if outside counsel determines that an in-house legal department has criminal exposure, reporting needs to happen to a separate audit committee and not to the in-house counsel. And those with criminal exposure need to be walled off from the investigation. So at the very beginning of your interview process, assess whether or not separate counsel is actually needed. And if so, ideally provide counsel before you gain any substantive information from that witness. One last point on this is if during an interview with an unrepresented witness, the lawyer discovers that the witness has interests that conflict with the interests of the company, the ethics rules do require the attorney to advise the witness to secure counsel. So keeping in mind the conflicts that may arise and doing that assessment up front is going to make things much easier. Okay.
Thank you, Angelina. Please go ahead. Please go ahead. I'm sorry.
Oh, do we have time?
Yes.
Okay. So just to recap, the pitfalls to avoid during an AG investigation include failing to properly prepare and having insufficient knowledge of the facts that are related to the case before your first contact with the investigating AG. Your first contact and really your future contacts are going to be important. Again, because rapport is important. Your investigations may be conducted from 1 to 4 years, and you'll be dealing with the same staff. Those staff are also the ones who will likely be making the recommendations to the AG as to whether or not to pursue another investigation or litigation. So again, really keeping the lines of communication open, knowing what your business is, knowing how your company works is going to be essential to establishing that rapport. At the end of the day, it's important to make the AG feel comfortable that your company can and will provide the information that they're seeking, and that if you can't, that there is a good reason why not. Another pitfall can be assuming that the investigating AG has inadequate information. Most likely, if you are receiving a CID, there are other CIDs that have been issued. Those may be to competitors, those may be to individual employees or to individual witnesses. Before a CID is issued, the AG is going to have done research, and they're going to have done quite a bit of information gathering about the industry and the business. So don't assume that the AG has inadequate information, but do be ready to advocate for the client and advocate on behalf of your client in terms of the narrative that you build. Advocacy is a very key part of your engagement with the AG, as is transparency as to your holdings of information or your processes. So that is something to keep in mind, that being very clear, being very responsive, frequently touching base, those are all good practices to avoid some of these pitfalls. Another pitfall may be neglecting to place a litigation hold on pertinent information and failing to understand the access points to those information. Again, the AG is looking at you to say, where are these documents held and what are the databases or other locations? And so knowing where those are allows you to limit the scope. Lastly, failing to enable and listen to the allegations. That's going to be important for your negotiations and narrowing the scope. You'll want to bring a representative of the client with you who knows the data and the organization, And understanding that overall investigations can sometimes impact a company's reputation. So being careful and mindful of that point is also important. So let me turn it over to Sam. Do we want to address questions at the end or no?
I believe so, yes. Thank you, Angelina.
Oh, go ahead.
Thank you, Angelina. So Angelina gave you much to think about. And the importance is AGs are different than prosecutors in the normal sense. They're different in scope. They're different in breadth. And if you have a company that often the FTC, the DOJ, state attorneys general are interested in, financial, consumer type areas, you don't want to wait until you get that CID letter in the mail. You want to be proactive. You want to know your state AG in advance. One of the first things companies used to tell me was, if you think that we made a mistake, if you think we didn't technically follow the law, give us a call and ask to meet with us. We prefer not to see a press conference where you're blasting us as our notice of your initial investigation. And I would suggest to you that while attorneys general can certainly be political, and noting the 30 of them are on a ballot next year, they really do prefer to have discussions with you in advance. They really do prefer to have proactive networking. And it is not to be understated that you want to know your attorney general. If you're in one of those industries, you want to know the head of their consumer protection, their financial section. You want to know them before they think there's a problem rather than after they think there's a problem. So what we suggest is literally get to know them, have meetings. We schedule meetings all the time. It is well worth it to have a meeting in an attorney general's office, meet with several of the main heads of their office and talk to them, talk about your business, talk about what you do, talk about your standards, your ethics and compliance policies, talk about how you're different, how you in fact seek to go above and beyond rather than the minimum required by state or federal law. It's frankly much appreciated. There are also national attorney general organizations that are the vehicles for discussion. But candidly, if you go to a regional or a national attorney general meeting, even if you get 5 or 10 minutes of that attorney general's time, they're frankly going to be thinking about the rest of the meeting and what they need to be doing later that day or the next day, whether they're on a panel, whether they're moderating, whether they're speaking. So it is often an appropriate place to say, here's my business card, nice to meet you. But the substantive discussions really need to be in their office, where you schedule an appointment and you have their time, you have their interest, and you have their colleagues that are subject to be most involved in any type of investigation. Once again, you want to talk about best practices as it relates to your company. And you want to specifically ask that they timely recognize and reach out to you, let you be in a position to tell them this is what we've done, we're fully compliant, or to frankly acknowledge we could have handled the situation better, we're correcting the problems, and let's have a meeting with you now, let's have a meeting with you 3 months from now, let's literally talk about the discussion. When there is a complaint, you want to be able to reach out to that person, not the AG, but the person in charge of that section of the office, meet with them, talk with them, and to see if it can immediately be worked out. With regard to engagement, absolutely, there's no downside. You want to, in fact, do that whenever there is a concern. That's just the type of thing that is good business. Angelina, did you want to respond to the question that we just received in this area?
Sure, I'm happy to. So I'm not certain, I couldn't point to specific case law as I sit here because it does differ across states. But in terms of applying litigation holds when the question is there any case law to support not applying litigation holds when AG's offices do not narrow an overly broad CID scope, or case law to support lifting litigation holds if an AG fails to file charges within a specific amount of time? So I'll tackle this, and Sam, please jump in if you have other thoughts. But generally speaking, you want to apply a litigation hold early on, and I would recommend applying it as if it is the broader scope. Now, if you think that there are portions that are just wildly irrelevant, such as, there are national subsidiaries that you think are not involved, that's a question of judgment and may depend on the specific facts in your case. But generally speaking, I would advise placing litigation hold broader. And as well as when you turn to lifting litigation holds if the AG fails to file charges within a specific amount of time, I think it is better to be conservative on that point. Sometimes, often, AGs will tell you when they have concluded their investigations, but it is better safe than sorry. So taking a more conservative approach to litigation holds is, I think, a best practice.
Totally agree with you, Angelina. So we're now going to talk a little bit about some of those organizations. Now, remember, these organizations are very instructive, very helpful, but please keep in mind that attending a meeting does not solve your problem. Introducing yourself to an AG does not solve a potential problem. It literally is that one-on-one or one-on-four when you're meeting with the senior folks. But these are the pertinent agencies, associations. There's the National Association of Attorneys General. We affectionately call it NAG. And that is a nonpartisan association of each of the 56 or 57 attorneys general. That includes, of course, the 50 states, the District of Columbia, the territories included. So Guam will be there, for instance. Puerto Rico will be there. Virgin Islands will be there. And it's not partisan in any way, shape, or form. They'll have a lot of discussions. Normally, when you have the meeting in D.C., for instance, the current president has spoken to them before when he was vice president. They do a really good job of getting many leading agency heads. They also have several working groups that are pertinent. They have an antitrust, a consumer protection, an automobile, as you're dealing with, for instance, how many miles per gallon, air quality, et cetera, as well as data privacy. And those groups are really important because, once again, as an individual attorney general's office doesn't have sufficient employees as a general statement, that's the ability for those offices to get together and maximize their overall value. You also have two partisan associations, Republican Attorneys General Association and Democrat Attorneys General Association. Now, you may sit there and say, but the Republican Attorneys General are attacking me, or the Democrat Attorneys General are attacking me. That's more reason why, frankly, you want to know what they're discussing and what they're talking about at those meetings. You want to be, shall we say, a fly on the wall. You want to know what types of businesses they're looking at. So, for instance, if you would have been at those meetings, you would have known when they started having an interest in Facebook or Google. It was years before the litigation. When I was Attorney General in 2011, we were talking about several of those social media companies. This didn't start in 2019 or 2020. So when you know that, you then have the ability to get ahead of the game, to further protect your business. Additionally, there's the Attorney General Alliance. Some of you that have been in the AG space for years may be saying, oh my God, what's the Attorney General Alliance? Well, that used to be CWAG, the Conference of Western Attorneys General. And as CWAG became more of a national symposium than a Western symposium, they changed their name to Attorney General Alliance. And I will unabashedly tell you, their programs as it relates to substance cannot be beat. When they do a program on a particular area, they are going to have leading general counsel, leading CEOs, and leading attorneys general speaking in that space. So from a perspective of quality of discussion, the Attorney General Alliance does an unbelievable job. So it's the type of thing, candidly, where once again, the message we're trying to send, I think, are twofold. One, be proactive. If your business is in a space that they're apt to be viewed by a state attorney general office, you need to get to know the AG now. You need to get to know the senior leadership in that office. So for instance, with President Biden's competitive order, things such as travel companies, things such as poaching of businesses, anti-poaching, restrictions on poaching, things such as the airlines and how long the plane's on the ground without flying before it goes to the gate. Many more industries are getting their attention, and the state AGs are going to follow those federal agencies to be part of that action. They do not want the federal government to be seen taking on these problems without their assistance. And I'm reminded, literally just 2 weeks ago, I saw a column about the Nebraska Attorney General, General Peterson, very good gentleman. But in that column, he was specifically talking about how much they reach out to federal agencies in advance when they think there's an issue to have them as a partner. That was not the case 10 years ago. 10 years ago, they really wanted to be in charge of their show and not to have the federal agencies with them much unless it provided a lot more artillery. Now they're viewing these federal agencies much more as a partnership, which I would suggest in general is a positive unless you're in one of those industries adversely affected. Secondly, as Angelina was talking about, don't apply the general rules. The general rules do not apply here. CIDs are not common in any other type of civil matter that I'm familiar with. And you cannot just say, oh, they're not going to send me a second letter. I don't need to respond by December 2. You need to respond. And you need a lawyer to respond who has a clue what a CID is. And Angelina, if you could possibly talk a little bit more about that, because I think often when lawyers don't see a subpoena or warrant at the top of that sheet of paper, they don't take it as seriously as they should.
Yeah, I think that certainly while I was an AAG at the state of Illinois, that was an issue that I encountered. And you really do need someone who is familiar not only with the CID process, but also with the state that's involved, both, as I mentioned, for relationships and also so that the state AG feels comfortable that I know this person, I know that they're generally credible and they do good due diligence, and they know my process. And the reason that that matters is because unlike generally perhaps normal discovery negotiations between partners or responses, there is just a lot more negotiation and interaction that happens at the state CID level. And so the state AGs know that these are broad. They are prepared to narrow them. That does not mean that that will always be successful, but failing to respond will effectively foreclose that opportunity to you. And it will also make it much more difficult for you to narrow the scope of the CID or to obtain extensions to respond or, to negotiate what the various discovery is going to be and how it is presented. So this is where familiarity not only with the process, but also generally with what the state AG will require is important. The other portion of this is that there are different methods of responding to a CID. Depending on your negotiations, you may produce documents and then wait to respond to interrogatories. You may do both simultaneously, depending on the case. And all of that is subject to your individual discussions with the AG. So certainly don't ignore it. As a former staff member, I can say I didn't love it when my targets ignored my subpoenas. And it certainly, I took a very careful eye to those folks as I was proceeding. The other aspect of this is, as I mentioned, there is some elasticity in the negotiations process, but always be mindful that this could end up in litigation. And so carefully tracking the type of that was requested, as well as the negotiated limits, is very helpful in litigation, because you can say that it was duplicative of the discovery that was obtained under the investigative subpoena or CID, and that will bolster your arguments later on.
Angelina, I think you froze. Angelina? Okay, I think you froze, so I'll jump in. I apologize. Angelina's frozen at the moment. Let me talk a second about 230, and as soon as we get Angelina back, clearly I'll have her finalize her comment there. We talked about Section 230 of the Communication Decency Act. We talked about Google and Facebook. I referenced earlier that this dates back to at least 2011. I remember an AG meeting where we had someone from Google there, and the issue was drugs that you could buy from elsewhere than the United States. And a Google representative said, "We're stopping that." And then there was a little discussion about fake driver's licenses. And Google said, "We've stopped that." Well, candidly, we understand how hard that is to stop everything bad on the internet. It's a real challenge. Having said that, the Attorney General at the time from Utah went on sites within about 2 minutes, showed them where you could buy drugs from other states, showed them a site where you could get a fraudulent driver's license, and that pretty much ended the meeting. Was that fair? Probably not. It wasn't really fair for either side at that point. Now you have it with Twitter, of course, with the former president and his interest in Twitter. That's not going to change. That's not going to change in next year's elections. It's not going to change in 2024. So any type of social media account is going to, of course, get their attention. Angelina, I think you are now back on. So if you would please continue, I apologize.
Certainly. So I do have experience representing a big tech company in a state AG action. And so certainly big tech is a target for state AGs, for federal regulators, and for Congress, as well as the FTC. I think that has been largely within the scope of antitrust, but it's also been within the scope of data privacy and some of the other issues, the CDA Section 230, for example. And it's a difficult question of how to enforce, how to regulate that industry, but it will be a target for a good long while to come. And so that's where really being aware of your industry and being aware of what, whether it falls into one of those areas of scrutiny is going to be important, but also having a narrative that suggests to the regulator how they might conduct their enforcement, or helping them to understand the different considerations of your business is going to be essential, even if you are the subject of scrutiny.
I don't. We have time for another question, but I don't see one down there. We have time for one if need be. I think the major issue, and I apologize because I know I've said this before, but it's worth repeating. Nothing beats familiarity. Nothing beats having a relationship with the pertinent leadership of a state attorney general office if you have a business in that place. When you see the Biden administration reaching out to state attorneys general to assist them, it's really vital that you go, maybe historically I haven't been involved in state attorneys general. Maybe historically I haven't needed to. But in my humble opinion, if you're in the healthcare, finance, automobile, social media, just more and more opioids, tobacco, you've got the recent issues with the vaping businesses. Even if you see an article with the FTC, it only takes one AG to add to that. So you need to be proactive. You need to be thinking of those ways and those opportunities to distinguish your business and to befriend those regulators like you would any other regulators in your business, so that they understand your business, they understand your desire to follow the rules and to, in fact, be a good player, a good corporate citizen. And I just can't say it any clearer than that. Angelina, any final comments you would like to add?
I mean, I concur wholeheartedly that familiarity is the best tool and really essential to the process. It really goes to trust and rapport. Other aspects of state AG, we went over some of the things that might provoke a state AG investigation. But state AGs do frequently also publish. And so keeping an eye towards that can also be very helpful, because if you see, for example, a staff member who publishes an article, it's likely that it's going to be, it's likely that that is something that's on their radar. So again, just monitoring AG's offices, being aware of what your industry, whether or not your industry might be under scrutiny, and having a good knowledge of how the AG's office works and a good rapport are ultimately the keys to success when it comes to receiving a CID.
Thank you, Angelina. In contrast to the normal CLE where you go a couple minutes over, we're going to do something different. We're going to finish a couple minutes earlier because I know my good friend Song Jung has plenty to offer with regard to their presentation. So at this point, I'm going to pass the baton to Partner and Global Chair of Intellectual Property and Technology, Song K. Jung, Partner Dr. Stefan Dittmer, and their featured speaker, James Pooley, who is an international trade secret expert of James Pooley PLC, who will provide the latest updates on global trade secrets. Song, please take it over. Thank you.
Well, thank you very much, Sam, for that very nice introduction. Hello, everybody. My name is Song Jung. As Sam said, I'm the founding chair of the Global IP and Technology Practice here at Dentons. And today, we'll be talking about one of our favorite subjects, trade secrets, with our partner in Germany, Stefan Dittmer, who is an expert in trade secrets law in Germany and Europe, and James Pooley, who's the international trade secret expert. He actually also testified in front of the Senate Judiciary Committee for the Defend Trade Secrets Act. I think Jim Pooley is widely known as one of the top trade secrets experts in the world. And together with Stefan, Jim and Stefan are co-chairs of the Trade Secret Task Force of the International Chamber of Commerce for the last several years. So they truly understand what is happening with trade secrets these days. So I think, we really have a lot to talk about in trade secrets. And trade secrets have been talked about in so many different ways. But since the 2016 signing of the Defense Trade Secrets Act, things have changed. And I think things have changed noticeably. Trade secret protection is now talked about and enforced in the United States and globally in a very significant way. I believe everybody understands trade secrets. We've had the Uniform Trade Secrets Act, and then 2016, as we discussed, Defense Trade Secrets Act was enacted. And the general definitions are very much similar. So it's not a new law in that new things have come about. It's really, we understand trade secrets, but now the Defense Trade Secrets Act is there to enforce at the federal level, and it is being enforced. If I can show you what's happening with the trends, and apologies if I'm going too fast on this PowerPoint, but please feel free to take a look at some of the basics of trade secrets. But I just wanted to show you a little bit about what's happening in the trends. Since the DTSA, there's about 30% increase of trade secret cases. And if you take a look at the DTSA cases versus the non-DTSA trade secret cases, there is a dramatic difference. The DTSA is now being enforced and used so much more than the non-DTSA cases, and some very, very highly publicized cases have used the DTSA cases. So if I may now actually come back to Jim Pooley, who actually testified in front of the Senate Judiciary Committee on DTSA. Jim, if I may ask, what are your thoughts on DTSA and what's been happening?
Well, thanks, Song, and thanks for including me in this presentation. It's pretty exciting. We're looking back on 5 years now since this act was embraced unanimously by the Senate. It's kind of interesting to think that there's actually legislation that is so bipartisan that you can get a unanimous vote. And what has happened is exactly what the framers of the statute intended, which was that we now have a federal option. It's not required. You can still go to state court as you traditionally could to get state remedies under the state laws, for the most part, the Uniform Trade Secrets Act. But that law, as it has been enacted and enforced by local courts, state courts, has not actually been very uniform. And so what the Congress wanted to do was create a platform for businesses throughout the country to have a predictable and uniform set of standards to go into a place, the federal courts, that they were familiar with, and get enforcement this way. And it has been a real boon for companies that have trade secrets that operate cross borders, state borders, and international borders, because the federal courts are very familiar with handling that kind of litigation. And interestingly enough, and this is something that you kind of have to read all the opinions to glean, but it's obvious to me that the the opinions that come from federal courts on the DTSA are influencing not just each other. They all pay attention to one another no matter what circuit that they're in, but also state courts that are implementing the Uniform Trade Secrets Act, which is almost exactly the same. And so this is having an even broader effect in terms of harmonizing the principles of trade secret law throughout the country, which is very positive news for for holders of trade secrets. Now, I mean, there's the sword has two edges, and the increased enforcement here means not only is there a place for companies with trade secrets to go to enforce the obligations of confidentiality in their business relationships with their former employees and so on. It also represents an exposure, because trade secrets are basically ubiquitous throughout the organization. There's a lot of sharing that has to happen in modern business. And as a result, people sometimes do things that they later regret. And we see disputes that now can be easily pursued with nationwide service of process and so forth, and that are resulting in very large verdicts. So we're seeing these days, not all in federal court, but in general, trade secret cases are generating verdicts in the multiple millions of dollars, some almost $1 billion. And so it's clear that these kinds of cases represent not just an opportunity for more robust management of information assets within a company. That's certainly true. But we're also seeing, as you've already noted, an increase in litigation overall. And that underscores the need for companies to manage not just the preservation of their own assets, but the exposure that they have for contamination of those assets with information that comes from elsewhere that they may not want. They certainly don't want the litigation. And so what this has done is elevated the whole issue to a higher level of management than it had before.
So Jim, obviously the DTSA has, in the initial stages, was a bit dormant, but it has now really woken up, and not only in the United States, but so many acts occurring outside the United States are now being litigated in the U.S., which we will talk a little bit more about later. But before we go to that, obviously there's been a lot of excitement about trade secrets in the United States. But Stefan, as someone who is a leader and an expert with trade secrets in Europe, what are you seeing in Europe in terms of the trends? Stefan?
Okay, now, thank you, Song, for having me on this occasion. It's a great honor. And yeah, let's just jump into Europe. What I want to make clear in the beginning is, like, when we talk about Europe, or when you think of Europe not as the United States of Europe, but think of it as 27 individual member states of the European Union. So it is still a fragmented landscape in legal terms in many ways, and it's not a United States of Europe yet. It may become so, but it isn't at present. And we do have, of course, European legislation. We have essentially two kinds of European legislation. One is the regulation, and that is actually law that applies directly in all member states. And we have directives, and directives need to be implemented into national laws within 2 years of their entry into force. So in terms of trade secrets, almost at the same time as the introduction of the DTSA occurred in the US, the EU had the Trade Secrets Directive in 2016. And it needed to be implemented by June 2018 into national laws of the member states. And it had a longer history. Of course, it didn't start in 2016, but the European Union realized, and the member states realized, that then there was a need for innovation. We had some unitary legislation in trademarks, for instance, and that helped a lot. And so we wanted to have like harmonization in the field of trade secrets, because everyone realized that you need like harmonized laws and to foster technology transfer, to foster innovation, and to foster competition. And so the intention of that Trade Secrets Directive is to bring all these changes about and make businesses in the European Union more aware of the value of trade secrets and give a more secure legal framework to exchange information, to share information with your business partners, and to have the legal framework that also allowed you then to enforce your trade secrets. So, and in terms of its content, the Trade Secrets Directive is not so different from the DTSA, but it has some significant gaps. So it does harmonize what constitutes misappropriation. It's essentially Article 39 chips. It also defines what are exemptions or exceptions from protection, like whistleblowing, for instance, freedom of expression, independent discovery, reverse engineering, and things like that you are probably familiar with. It also harmonizes remedies and the preservation of secrecy in legal proceedings to a certain extent, but it does not harmonize access to evidence prior to legal proceedings. And for instance, the territorial jurisdiction of the state courts. So the bottom line is it's a great step forward for Europe, but if you need to litigate your trade secrets in Europe, you have to look at the states, at the member state, and at the legal systems of the member states, of the judicial systems of the member states, and because this is still subject to local jurisdiction.
Yeah, I should add that those who are interested in more details about this issue can take a look at the report that Stefan and I oversaw the preparation of, that was just published. I think it was 2 years ago, wasn't it, Stefan? Comparing the situation in Europe and the U.S. in this very unusual circumstance where business interests in both places promoted an approach, a more unified, harmonized approach to trade secrets. And I think Stefan's right. It went farther in the U.S. because we have a more unified, homogeneous federal system. But it went very far, actually, in Europe with a common definition and with certain procedural safeguards that weren't there before. Now, there's no common approach to criminal liability for trade secret theft. There are some states, including Germany, where that's available, but not all. And of course, the problem, if you will, the challenge that exists in most civil jurisdictions, that the owner of the trade secret, the putative victim of the theft, doesn't know what happened and doesn't really have a powerful mechanism in Europe in civil law jurisdictions for finding out what happened. In the UK, it's a bit better because they have they have their common law traditions that allow something that looks a bit like discovery to happen. But the only place where you can get kind of full-on discovery based on reasonable suspicion that something has happened is still in the U.S. So I think most of these jurisdictions are doing what they can within their national frameworks to harmonize and optimize the usefulness of trade secret laws.
I think you raised a very important point about trade secrets. It's very difficult to prove as a victim that the perpetrator misappropriated and stole your trade secrets. Now, obviously, in the United States, we have discovery that gives us tremendous leverage. And when we get into litigation, to find out exactly what happened. But in countries like Europe and, of course, countries in Asia, it's very difficult. And even if you could enforce. It's been very difficult. But China, there's an inflection point happening in China.
Yeah.
China very recently changed their laws to shift the burden to the misappropriator. And so in the past, it was very difficult because the burden was on the trade secret owner to prove almost everything. And that's almost an impossibility. But
at the beginning, when you walk into court.
Yes, exactly. But now the Chinese laws have been revised so that the trade secret owner simply needs to prove that you have a protected trade secret and that there was accessibility by the perpetrator, and that the accused violator, they have a product that is substantially similar as yours. Once you pass that prima facie evidence, then the burden goes to the accused infringer, accused violator. And that's a significant change, isn't it, Jim?
It is, and it's something that has been under discussion for a long time, and the authorities in China have been focused on it, recognized the nature of the problem, and I think the Phase 1 agreement between the U.S. and China perhaps helped move that along. But China has now embraced this burden-shifting approach to the inherent problem of asymmetry of access to information about what happened. And so I think in a civil law jurisdiction, that's about the most that you can expect. That is that when the company that feels that it's been victimized comes in and makes out just a basic prima facie case. That is, these people had access, they had the opportunity to do this, and look, they've done something that looks similar. We have reason to believe this, and if that looks plausible, then the burden shifts to the defendant to prove independent development. That is, development of whatever it is that they did independently of access to the trade secrets. And that helps even the playing field in any civil law jurisdiction. It's quite a big step forward.
Right, it's beginning to look like a copyright case, correct?
Actually, the Chinese have actually improved their system that way too, because in the past, what they considered to be misappropriation had to be almost a virtual copy. And as we all know, trade secret information can be used to influence or accelerate another company's innovation in the same area, but with an outcome that looks very different. And so one of the changes that China has made to its law is to recognize this notion of indirect misappropriation, where the thing that the defendant has made doesn't have to look exactly the same for a misappropriation to have occurred.
Yes. Now, speaking of the Asia region, recently, and we'll talk about this case, there's been a humongous case, a historic case where LG sued SKI at the United States International Trade Commission, and the actual act of trade secret theft occurred in Korea. And now, because of the limitations in a civil jurisdiction, as we just discussed, LG decided to bring the suit in the United States. But what's happening in Asia is that I think this case has really, really caught the attention of not only Korea, but all over Asia and all over the world. Obviously, the United States, because United States ITC was where this case was litigated and became a widely publicized case. So a case like the LG ITC case, in Asia, laws are being changed and to make it easier on the trade secret owner. Do you see that there will be a trend giving more of the benefit and help to the trade secrets owners in Asia?
Well, yes. I mean, I think you're too modest to mention it, Song, but this case that you led on behalf of LG Chem resulted in the largest trade secret settlement in history, almost $2 billion. Now, they're going to take notice of a result like that. So first of all, congratulations. And yes, it is going to have an effect because it drives home the message that in modern business, although we're fond of saying that intellectual property laws are territorial, but trade secret enforcement and trade secret exposure is global. And so companies in their operations need to pay attention to how what they do might be interpreted and how it might be disputed in some other jurisdiction under laws that they may not be entirely familiar with. And so this, again, raises, particularly, I think, in countries in Asia where have not been traditionally enforced very vigorously, this raises the bar of concern, certainly.
Absolutely. So now, whether you're in Asia, Europe, or anywhere in the world, you have options. You have options to stay within your jurisdiction, or you can go to another country like the United States, where laws like the DTSA is giving you options to litigate. Stefan, how are all these major cases around the world affecting Europe? Has Europe taken notice here?
Of course, Europe has taken notice, and Europe is looking back at a history of not very many cases, which is a direct result of the deficiencies of like local legislations in terms of protecting secrecy of the information in legal proceedings. And so the directive that I mentioned earlier is designed to remedy this and to provide better protection to litigants, to the trade secrets owner, and so that they actually use the judicial system to enforce their trade secrets. I mean, one of the biggest trade secrets that the audience may be aware of dates back to the early 90s. It was Mr. Lopez who joined Volkswagen from GM at the time, and apparently brought over like a huge amount of trade secrets. And the interesting thing is there was action in Germany and in the US, but the action in Germany was not a civil action. The action in Germany was a criminal action, and this is. This may be. I mean, it depends always on the details of the case. But Germany has a long tradition of like claimants or trade secret owners relying on the criminal side, so on criminal laws, to pursue trade secret infringements, which is also a result of the absence of instruments for access of evidence. Prior to an action. So what you can do, you can go to the state prosecutor and have them do the business of securing evidence and by like seizure orders or something, and then you can use that evidence later in a civil action if you want to. So. Yeah, but your question was, do we pay attention? Yes, we do pay attention, and I think we will see more trade secret cases in the future now that we have like the better instruments in place across Europe that are meant to facilitate the enforcement of trade secrets.
Right, in that Volkswagen case. I'm sorry, go ahead, Jim.
I was just going to say that Stefan pointed out a very good example there. With the the Volkswagen Lopez case, it just so happened that I was on the Volkswagen team back then when it happened, and the prosecutor in Germany was the most important pressure point in this multi-jurisdictional litigation, because in Germany the prosecutor has enormous powers to investigate, and was very effective in that action, and keeping the pressure on, which also resulted ultimately in a very significant settlement. But I think most of the leverage there came from the German action rather than the U.S. action in that case.
And as we know, that was also a very widely publicized case, and the case settled with the amount totaling equivalent to about $1 billion, where Volkswagen had agreed to purchase parts from GM, and that was the largest trade secret settlement case until the LG case. But let's go around the world a little bit more. Australasia is also very much has very good trade secret laws, but it's trying to follow Europe and the UK. Anything interesting happening in Australasia, Jim and Stefan?
Well, I mean, if we're speaking Asia generally, I think you've hit on the place where the most interesting things are happening, which is China. But there have been revisions to trade secret laws in both in South Korea and in Taiwan, and if we're going back a couple of years, Japan as well. And Australia is, like the UK, a common law jurisdiction that has a tradition of trade secret enforcement in its common law courts. So there's bound to be more and more activity when simply you look at the attention that governments have been paying and legislatures have been paying to this issue with the enactment of new laws specifically designed to deal with trade secret theft.
Right, and as we move along now to Latin America, we haven't seen a lot of activity in Latin America with trade secrets. Stefan and Jim, have you noticed any trends there?
Jim?
Stefan, you want to?
Or Jim?
Okay, well, I'll just speak first then. I have some experience dealing with some of the countries in Latin America from the time that I was with WIPO, and I would go around and talk to some of the government officials who were engaged generally in intellectual property enforcement, and it was very interesting. There was widespread interest in certain countries, Chile, for example, Mexico, and some ambivalence in other countries like Brazil, for example, around IP enforcement generally, although that had to do mostly with patents. But my observation in talking with colleagues and other folks in that region generally is that trade secret litigation is largely hampered by the restrictions of the civil law process in those countries. And so most of what you can get in terms of enforcement will result from special provisions in your contracts that will then, can then be used in contract enforcement litigation, or in some cases, in some jurisdictions, criminal. But there's been a fairly low level of activity, certainly relative to some of the other regions.
So we've gone around the world talking about what's happening, the latest trends, and what are some of the issues. So now let's go into what worries, what are the compliance issues, and what are the strategy issues at the board level in these global corporations. What have you seen, Jim and Stefan, at the board level concerns?
Well, generally, there has been an emerging awareness that what companies are dealing with here is just is another form of asset protection and management, a very important one. Obviously, in the information age, data is the most important asset that most businesses have. But what we've seen is an emerging sense that there are both dangers and opportunities here. There are risks to losing some of this information. There are risks in contamination when you deal with some third parties or hire in high-level executives from competitors and so forth. But there are also enormous opportunities to increase enterprise value by managing these data assets in a way that lead to new products, new service lines, new markets, and so on, all of which translates into paying close attention both on the governance side and on the operational side to sort of what's going on. I mean, we used to see the old patent committee in every organization. Increasingly, this is called the innovation committee. And instead of just deciding whether some innovation should be patented, and if not, it falls on the cutting room floor, now there's a much more sophisticated process at work where those who look at the innovations that occur and are deciding what should be done about them. It's not just the external patenting process, it's about management within the corporation. Who is it that's going to be watching over this particular asset to ensure that it gets commercialized in the right way? Whether it's increasing the efficiency of operations, lowering costs, whether there's some licensing out or joint venturing that needs to be done in order to capture its value. Those things are much broader now than they used to be, and they result in new business processes and new responsibilities for managers to ensure that the process is carried out.
So strategically, when so much innovation occurs on a daily basis in these corporations, but you need to capture and protect and make decisions on these innovations. So I see one of three ways an innovation can go. One category is to patent the innovation. Another category is keep it a trade secret. Another is to not protect it, but if you're not going to protect it, one must be careful that it does not come back to haunt you. So I remember IBM was very, very active in this area from the very beginning, where they would have periodic meetings and they would come with invention disclosures that we now call innovation disclosures. So they would decide, should we patent this invention? Or if not, should we keep it a trade secret? Or if not, why don't we disclose it so that no one can get a patent on it? But if you go through that process, you're automatically categorizing and registering whether it's a patent or a trade secret, so that you're constantly monitoring and managing.
Yeah.
Do you see corporations? Please go ahead.
Yeah. Well, IBM is a great pioneer in that sort of thing, particularly in publication to maintain freedom to operate, as it's called. But just an important comment there. You're right about the various categories, but we all need to remind ourselves that these are not mutually exclusive and distinct. A given product or process may involve both patents and trade secrets, and that process of using both in the same area became a whole lot easier after the American Invents Act from 10 years ago took what we used to have as a barrier in the U.S., which was the requirement to disclose the best mode, and changed that. It didn't eliminate the requirement, but it eliminated the consequence of not disclosing the best mode, so that companies are quite free now to patent an aspect, a patentable aspect of an innovation, while still retaining as a trade secret very closely related innovations that are about how you implement the invention in the most efficient or productive way. And so this has opened up a lot of new areas for smart management of innovations across various IP regimes.
So we all want to try to have cake and eat it. You want the patent and you want the trade secrets as well in your strategy. Stefan, in Europe, obviously the EPO is very busy publishing and granting patents. Trade secret protection is part of a very important strategy together with the patents. What are you seeing at the board level on protection of trade secrets, and what are the strategies in Europe that you are seeing from these major corporations?
Yeah, well, I can only echo what Jim already said about the importance of management of trade secrets. Although my impression from my own client base is that there is a lot of teaching efforts still to do in terms of the trade secrets management and raising awareness of the importance of trade secret management. And the interesting thing is, 2 years ago, when the Trade Secrets Directive, or 3 years ago it is, when it was supposed to have been implemented in the member states, that almost coincided with the entry into force of the GDPR. And so management totally focused on GDPR at the time, and more or less didn't pay attention to this very important development in trade secrets law. So what we have done since is to try to teach management, to try to teach in-house counsel about the relevance of having an effective trade secret management in place. And the interesting thing is, also echoing what Jim said, the data economy. I mean, this is something companies are very aware of. I work a lot with automotive companies, and they create a wealth of data all the time, and they actually focus not only on the legal side but also of course on the business side of data. But through this sort of detour on the value of data, they come to realize that they need some sort of protection, and that's how we can lead them to the option to protect their raw data as trade secrets, and also algorithms that they require for creating self-driving vehicles and all this. So yes, awareness is definitely growing, but it's still some way to go.
Yeah.
Understood.
Stefan raises a very good point here, which deserves emphasis, particularly given the main audience that we have today, which is inside companies. And in my own work advising companies about this, we often hear the reaction because, of course, as I've said earlier, trade secrets are everywhere. It's about data. It touches every part of the organization. And so when you introduce the idea about managing trade secrets, sometimes people's eyes glaze over and they wonder, are you suggesting that we boil the ocean? How do you manage something that has so many aspects and so forth? And there's actually good news around that. First of all, the process of management is no different than classical organizational risk assessment and management. And secondly, you don't need to shut down the hardware store and go in and count all the bolts and nuts. It's sufficient to focus on the things that really matter. And the managers of each business unit or functional part of the organization are well aware of what are the outbound risks, what are the inbound risks in their part of the business. And so it's not that hard to create a very, appropriate list, prioritized risk of the things that really matter, and then start to consider how do we mitigate those risks in a way that's acceptable to the culture and the budget of the organization and so forth. So it's not as difficult as it might sound, but that attitude, that pushback, oh my God, how can we possibly do this, is very common.
Well, it's while you mentioned that it's not as difficult, but at the same time, when as a trade secret owner, when someone has misappropriated your trade secrets and stolen your trade secrets, and you file a lawsuit, and you begin to try to understand what is the trade secret that has been violated. When you try to list the protected trade secrets of your company that have been violated, it's not an easy task. And in fact, I find that many of my clients in a trade secret case have to think and actually understand exactly what is it that we know they took our confidential information, but not all of that is trade secret. And did you really protect it? These are very simple and basic questions, but it's sometimes more difficult to answer the basic questions. And I think this is where the preparation and the management all become very important prior to any type of a lawsuit on a daily basis.
Oh yeah, you're so right, Song. I think we've all been there before. We have to go in and try to get some sort of temporary restraining order or some other immediate relief. And all of a sudden we're sitting down with a blank piece of paper trying to identify what are the assets that we're there to fight about. And so, yes, one of the advantages of paying attention at just a basic level to the management of trade secrets in a way that gives you a strategy and a general approach to defining what you own. One of the advantages is that when you do run into a dispute, you will be prepared to sit down and understand what you're talking about to a court, and you'll also be able to make better decisions about what sorts of risks to take in the litigation itself. So it's helpful all around.
So speaking of litigation, there have been many very important litigations that we all need to understand. And we've named, we want to talk about 3 of those today. I think you're going to talk about the Epic versus Tata case, as well as the Waymo case. And it's all about the employee, isn't it?
Yeah, it is in different ways. So first, the case that you may not have heard of, the Epic versus Tata, was about employees from Tata, a consulting organization that had a client, a customer, in common with a competitor, Epic. And what these employees did in dealing with their customer was entice the customer to treat them as if they were the competitor and share with them some of the competitor's information. It was not an appropriate thing to do, but they did it. They got some information, and that information, it was just business data, strategy kinds of things, influenced the creation of Tata's internal strategy to such an extent that when the case actually ended up in front of a jury, they awarded hundreds of millions of dollars in damages together with punitive damages. And the behavior by the employee, who one might conclude was not adequately managed or trained or what have you, had this enormous consequence that nobody anticipated and certainly wouldn't have looked for. The and so that was a case in Chicago. And then most people here have probably heard about the Waymo Uber case, which was about another way in which problems happen because of employee behavior. And this is about the hiring of a high-level executive, in this case, the person who was in charge of the engineering program at Waymo, the Google subsidiary that was working on self-driving cars. And the folks at Uber decided they had to hire this guy named Lewandowski. He was so important. He would be able to lead them to the place that they needed to go, which was presumably getting rid of all of their drivers. And so anyway, they found out early in the process that he had done something pretty dumb, which was to download, before he left Waymo, thousands of confidential files, which he felt that he needed to talk to them about his employment situation. Whatever, he had done this, and he had them there. They knew it was a problem, but they were the company, Uber, was so intent on making sure that they got access to him and that they were able to hire him, that they actually ended up entering into an agreement not only to sort of keep things quiet and have him start another company that they would later acquire for hundreds of millions of dollars, but they also gave him an indemnity against any claim that Waymo might make for what he had done. In other words, they knitted themselves very, very closely to some of the bad behavior that he had engaged in. Well, we all know what happened. He ended up getting fired. The judge in the civil case referred it to for criminal prosecution, and he was prosecuted. Uber ended up spending hundreds of millions of dollars on the litigation and settling it, and they gave about $250 million in Uber stock. So again, an action involving a single employee that turned out to have enormous consequences for the organization, consequences that could have been avoided.
Yeah, which was very similar to the Volkswagen GM case. But in the case of LG versus SK at the ITC, it wasn't about one employee. It was about 100 employees that went from LG to SKI. But before we go into that, I was told that I now need to inform everybody about the CLE code. And the CLE code, I hope everybody's ready, is everybody ready? It's diplomat. So if you're licensed in Kansas, New Jersey, New York, or Pennsylvania, please write the code in the pop-up box that appears on your screen. By the way, if you don't have a license in any of these states, you don't have to worry about the step. It is only required for Kansas, New Jersey, New York, or Pennsylvania. I will give you a few more moments so that you can write down diplomat. And so as you're completing your process, the LG SKI case, which settled very recently, was an ITC case that LG brought in the United States, but all of the misappropriations, or the vast majority, occurred in Korea, where SKI hired away about 100 LG employees, and it was all in lithium-ion batteries. And these employees were not only engineers and scientists, but they were in business, marketing, and so many different areas of the entire business. And they brought with them trade secrets. LG learned about all of this because they did their own internal forensic analysis and learned that most of these employees downloaded internal documents. And in fact, these employees used LG's proprietary text messaging system, and LG was able to through their forensic analysis, bring back a lot of these text messages that the engineers and former employees thought were erased. So it was a shock to both LG and SK, and they used the part of the DTSA allowing LG to sue SK because SK was building a major $2.7 billion lithium-ion battery plant in Georgia. They had recently obtained supply contracts with Volkswagen and Ford. And so it became a widely publicized, widely known case. And of course, President Biden came out with a supply chain memo that heightened the scrutiny of these cases. On the one hand, you had a massive violation of trade secrets, which never went to trial because the trial judge at the ITC found that SKI had inappropriately destroyed documents, many tens of thousands of documents, and they could not recover it. So 2 weeks before trial, the judge granted a default motion, and about a year later, the commission affirmed it. Now, of course, after the commission affirmed at the ITC in the United States, there's a 60-day presidential review period. And it became very, very political, legal. Every possible issue that could come up in a case had come up. And ultimately, it settled for $1.8 billion, was widely publicized. But it was a very difficult situation where you knew there was violations. But then Volkswagen and Ford had to have these supply of lithium-ion batteries so that they can make their EVs. But on the other hand, how do you let this violation? How do you reward the violation? So it was a very difficult situation, but it ended up settling, and I think it was a lesson learned in a very significant way for not only LG and SKI. Obviously, SKI didn't expect this much of a lawsuit in the United States. And LG, having lost so many of its employees and its trade secrets, its crown jewels, they learned the hard way what can happen in a situation like this. And obviously, the whole world became aware of the situation. But I think we've seen not only the LG case, but we've seen many other cases with very large numbers, and also with foreign companies coming into the United States to use the United States courts under the DTSA and other laws to enforce their rights. Stefan, Germany has seen some of these trade secret cases, and Europe. There's multi-jurisdictional cases that you talked about as an example with Volkswagen and GM. There are obviously trade secrets is not contained within a one country. The strength of your trade secret protection all depends on where is your weakest link, and in Germany, while patent system is very strong, and so many companies go to Germany for their injunctive relief, assuming that you have a very good case in Germany, what are some of the damages that you can see in Germany and Europe, and remedies?
Well, it's essentially the same across any IP infringement. It's injunction, it's information on the extent of the infringement, like what did you sell, to whom did you sell, and then damages. And the damages can be calculated in different ways. Can be like the actual damage that the trade secret owner or the IP owner suffered. It can be, so for instance, a loss of profit, or it can be also the profit that the infringer made based on the misappropriation. And it can also be a fictitious license fee, like what license would the infringer have had to pay if he had asked the IP owner for a license. So these are essentially the ways to calculate your damages.
So obviously, Jim, damages in recent trends have been huge. Do you see this trend continuing in the United States?
Well, yes, I do see it continuing because, I mean, honestly, large 9-figure verdicts tend to attract attention, and people pay close attention to, their own situation, and lawyers are encouraged by seeing these sorts of outcomes. Obviously, we also have ready accessibility to punitive damages in the U.S., which makes these verdicts even larger. Our general law on trade secret theft is restitutionary and it's tort-based, and so we always want to make the victim whole. And so the ways that juries look at damages tend toward the unfair advantage that was reaped by the defendant, which can be a huge number, even if the defendant didn't do so well with the information and actually incurred a business loss. So those kinds of factors mean that trade secret litigation will continue to be the kind of action that leads to big verdicts, and it doesn't hurt that the U.S. through the DTSA and through the ITC, as you just mentioned in relation to the LG Chem case, has decided that we really care about misappropriation that happens somewhere else in the world, so that if there's a connection, if the information is owned by a U.S. company, or if there's some other connection with the U.S. sufficient to allow jurisdiction, our courts will reach outside the U.S. and take jurisdiction over an act of misappropriation that occurred entirely somewhere else, so long as it has effects that are felt in the U.S. And that was the case with the recent Motorola Hytera judgment in Chicago, that again, multiple hundreds of millions of dollars for a misappropriation that happened entirely in Asia. So this is this aspect of U.S. enforcement, that is, its extraterritoriality, adds another dimension to the popularity of trade secret litigation.
Yes, and as we know, please go ahead, Stefan.
Yeah, just wanted to jump in because Jim spoke about extraterritorial jurisdiction. I mean, we don't have it in the way as the US has it, but there is some kind of this also within the European Union. We have the so-called Brussels regulation. And so when you sue a defendant in the place of where he's registered, where he has a registered place of business, and you have suffered damages like in various EU member states, the court in that place can actually award damages that were suffered in any of the member states. And you can also, under the Brussels regulation, you can also sue the defendant in where one specific damage occurred, but then you can only liquidate the damages that occurred in that specific country. So there is a sort of limited extraterritorial effect also of litigation in Europe, and that also applies to trade. That's not to be clear, it's not trade secret specific, but it also applies to trade secrets. As I mentioned earlier, the directive, the Trade Secrets Directive, is silent on all this, so we basically apply the general rules, and these apply also to trade secrets litigation.
Yes, and I do want to mention at the ITC, as we know, ITC, there's no damages. It is simply an exclusionary order at the Customs and Border Patrol. Interestingly enough, in the LG versus SKI case, the commission allowed Volkswagen and Ford, as well as Kia Motors, to be able to be supplied with SKI's batteries as a carve-out. Now, in the history of the ITC, there's never been a carve-out for customers where the product has not already been in commerce, already been sold to the customers. But in this particular case, because of the importance of the lithium-ion batteries, and because in the automobile industry, it takes a long time for any changes in the specification or parts. It takes a long time for to be certified. The commission, seeing the urgency of the lithium-ion batteries and EVs, allowed for 4 years of carve-out, and Volkswagen 2 years of carve-out. The Volkswagen received only 2 years because Volkswagen's platform was a standard platform where multiple suppliers could supply to Volkswagen, whereas Ford, only one supplier could supply, according to Ford, the batteries for, at that time, it was specific for the EV version of the Ford F-150. And for Kia Motors had been bringing in their EVs with SK's batteries, and the carve-out was an interesting order. They only allowed the carve-out for Kia Motors vehicles from up to the date of the order. So any replacement parts that needed to go on a Kia Motors EV car, there was a cutoff date. So the interesting part with Kia under that order is that what happens to those Kia Motors cars coming in post that date? Well, why would anybody want to buy a car that you cannot get a replacement with, according to that order? So I think there's a lesson to be learned on these carve-outs, especially Kia Motors situation. So, and obviously we can talk about these cases all day long, but I see that we're coming very close to the hour here. I do want to talk a little bit about balancing the trade secrets and patent protection. And as many of the patent attorneys know, there's a danger to holding on to technology and keeping it a trade secret, because after a certain period, you are barred from filing a patent. For example, let's say you have a very important process that you want to keep trade secret. If you keep that process as a trade secret, you're making products using that secret process. Now, after 1 year of selling that product or disclosing that product for the United States, you are barred from even filing a patent for that secret process. Now, I don't think that is the case in Europe, but you can understand how the different strategies might come about depending on whether you're in the United States or Europe and other parts of the world, where you may get you may have cake and eat it. You may want to keep it a trade secret for a few months, less than a year, and then file in the United States, for example. Or you can keep it as long as you believe you can keep it a trade secret in Europe, assuming that you do not need the United States. So these are different strategies when balancing trade secrets and patent protection is one of the issues to consider. Any final words, Jim and Stefan? Maybe we can talk about trade secrets and patent protection or any other issues that we've talked about so far.
Well, just on that last point that you made, I think we referred earlier to the fact that with the American Invents Act 10 years ago, we got relief on the problem of having to put trade secrets into a patent because of the best mode issue. That's pretty much gone away now. The other thing that happened on this point in the AIA was the establishment across all technologies of a prior user right. And although it's not ideal, it does provide a safe harbor for companies that that have installed a process, they can continue to use it in the place and in the location and in the way that they were, even if somebody else later on goes in and files a patent that would otherwise cover it. So we have a little bit better environment these days for trade secret management relative to patenting than we did before.
So and I know time's up, but I'll make a quick example. Let's say you have a technology where you need a temperature range of 100 to 200. Now, you can disclose that in the patent, but let's say a range of 155 to 160 is the best range. You don't have to specifically disclose that in the patent, but yet you can keep that as a trade secret. So you can have best of both worlds. And that is one of the examples of how you can have cake and eat it. But I know our time is up, and I'm sorry that we went a minute longer, but I hope this was helpful. Jim, Stefan, and I would be happy to answer any questions by email, but we hope that this was helpful, and we hope that we can have another opportunity to discuss this matter with you. Thank you, Jim, and thank you, Stefan.
Thanks very much.
Thank you. Thank you, Song. Thank you, Jim, and thanks to the audience for listening.